Hello everybody, I'm George from Ireland. So this is my English law channel. I'll try and block out the light in my head. And so this video is going to be about the monarchy in law and the royal prerogative. So the UK is a constitutional monarchy, not an absolute monarchy. And this emerged through the centuries. Won't go through all the stages, but even the Anglo-Saxon kings promised to rule within the law, not to exceed their regal powers, and within the Conqueror and subsequent Norman monarchs swore the same, though parliaments very seldom met. But only significant progress was made in the 17th century after the English Civil War, then the 1688 Revolution, called the Glorious Revolution by its partisans. The Bill of Rights was passed in 1689, which established various things, such as the supremacy of a parliament over the monarchy, and that the parliament had the right to alter the line of succession, something they did by the Act of Succession later on, excluding 58 Catholics when Queen Anne died, to going to the nearest Protestant claimant to the Crown of England, likewise the Crown of Ireland, Crown of Scotland. So the Parliaments of Ireland, Scotland and England and Wales all agreed on that one. Anyway, so obviously the monarchy is a hereditary position, and Catholics were specifically excluded from it. I think those who are married to Catholics are not any longer. They used to be till about 10 years ago. Now, the monarch of the United Kingdom, he or she is the supreme governor of the Church of England. But do they actually have to be a member of it? I'm not absolutely crystal clear on that one. So we know that there are rules about what the monarch's role is. Some of these are conventions, not actually laws. So, and this is what was said by Bradley and Ewing, these two famous legal scholars: the Queen may reign, but the PM and other ministers who rule. So she is a figurehead. Her role is totally ceremonial. Go back to Lord Coke, the famous 16th century judge, said in the case of proclamation 1611 that the king hath no prerogative but that which the law of the land allows him. So even then Coke, or Cook, some people think was pronounced, was suggesting that a limit was set to what monarchs can do, although I don't think James I would have accepted that. He believed in the divine right of kings. So the monarch cannot change statutes, repeal them, cannot amend common law or anything like that, or cannot invent new crimes. So anyway, so the Bill of Rights in 1689 is not a human rights act as we would think of it, but it said that parliaments had to meet frequently, and if the king didn't summon them, they could meet without the king's say-so. That there were elections, and the king couldn't bar people from standing for elections, couldn't annul results, and so forth. That there was a freedom of expression within Parliament, not outside. You'd be surprised how constrained free speech was at the time. You even needed a license to preach. So the established churches had them. The Church of Scotland in Scotland, the Church of England in England and Wales. Ireland, we had the Church of Ireland, even though the majority of us were Catholic. So parliamentary privilege was the right to say whatever you wanted to in Parliament, which hadn't always been the case. You go back to the 16th century, and some monarch said, like, none of us without fault, no, not even our Queen, and he was put in the Tower of London to cool his heels for a few months for his impertinence. But now you can be that impudent. So the Bill of Rights also said that nobody can be taxed without his own consent, which goes back to Anglo-Saxon times, but Parliament would consent to taxation, and everybody was represented in Parliament. That was the idea, even though only rich men had the right to vote. Oh yes, but the wealthy are voting on behalf of the paupers. That was the theory. Anyway, so we know that the Queen, she is the monarch of 15 Commonwealth realms, as in Australia, Canada, Barbados, not anymore, not since last month, Jamaica, Papua New Guinea, New Zealand, the Solomon Islands, Vanuatu, and a few more. So the Succession of the Crown Act in 2013 said that in future the eldest child inherits, not the eldest male, because you had to be born inside wedlock to have any right of inheriting, which is discriminatory. I mean, the whole thing is inegalitarian, and favouring elder over younger, and he used to favour male over a female. So it goes to Prince Charles and the Queen's death, and then his eldest son William, and then William's death, his eldest son George, and then his daughter Charlotte, and only then Louis. In the old days, it had been Louis before Charlotte, because Louis is a boy, even though Charlotte's older. So, and then it would go to Prince Harry if all those die without any children. Okay, So Walter Bagehot read his English Constitution, published famously in 1867. He ought to have called it the British Constitution, but England is widely understood pars pro toto synecdoche. He said that the monarch has the right to be consulted, the right to encourage, and the right to warn. So Bagehot's book, we just usually call it Bagehot, is known as is regarded as a work of authority. Says who? There's no statute saying this has any constitutional significance. But anyway, it's generally regarded that this has some constitutional import. So the Prime Minister has a tete-a-tete with the Queen once a week, and nobody else is there, no notes are taken, that's it. And he is made to stand, not offered any refreshment, to get to the point, to do it quickly. Queen Victoria brought that in. So to unburden himself of things, and then she can advise him. We'll say, oh, it keeps him on the straight and narrow, that keeps him bowing, it occupies that sort of square so that the politicians can't get over mighty and take over. That's the monarchical justification. If you're anti-monarchist, you might consider that bunkum. So the monarch receives copies of cabinet papers and other critical documents. So she's not supposed to have any influence. But these weekly meetings à deux are said to be useful. Like John Major said, there was a Commonwealth conference, and the Queen said, "How's it going?" And he said, "Well, so and so is being obstreperous." He didn't name the person when he revealed this because the content is confidential. And the Queen said, "Well, you can talk to him about whatever, one of his pet topics." And so that established a rapport. That's how useful it is. But they're not all diligent doing their homework. And Edward VIII was thought to be such a security risk, considered to be deeply sympathetic towards Nazism, that the government took the unprecedented step of not circulating some highly sensitive documents to him, lest they find their way to the Third Reich. Anyway, this idea that the monarchy is meant to be above politics, or for example, when Prince Charles, when he went to Cambridge, it was decided there were certain things he could not join. He could not join the Labour Club or the Conservative Association, anything like that. The monarch has no right to vote. Other members of the royal family do, but by convention they don't vote. Now, if you go back to, say, the reign of George III, his son, George IV, the Prince Regent, was an ardent Whig for a time, later on a Tory. And through the 19th century, the monarchs, they opined, they made their views very plain. Even Edward VII, when he was Prince of Wales, he was in the House of Lords and he was on certain committees, admittedly doing non-contentious things. So talk about the Crown, and actually came out in a court case. The Supreme Court said this a couple of years ago, that the Crown really is a constitutional abstraction and is not an individual. Anyway, so other things to bear in mind. Then there's the royal prerogative, or the Crown Prerogative, we sometimes say. So prerogative is something but both a right and a duty. So there was the recent case of Miller and Secretary of State for exiting the European Union, 2017 Supreme Court case. This crystallised some of these. The Miller number 1 case, there are a few of them, with Miss Miller, who's trying to thwart the popular will and prevent the United Kingdom withdrawing from the European Union. So this is what the Supreme Court defined Crown Prerogative as in that case. They said it is the residue of powers which are vested in the Crown and are exercisable by ministers, provided the exercise is consistent with parliamentary legislation. So these governmental ministers, they exercise these prerogatives on behalf of the monarch who ceded them. Remember, she only acts on the advice of her ministers and signs every single bill that's put forward to her. No monarch has vetoed a bill since Queen Anne, well over 300 years ago. So however much they detest legislation, they pass it. Even George III, he vowed that anyone who voted for the India Act would be his enemy for life, but it was still passed. So monarchs used to have very broad discretionary powers of patronage, but they've divested themselves of these down the centuries. So there are two widely known definitions of a prerogative. One of these is from our old friend A.V. Dicey. Here is what he says: the residue of discretionary and arbitrary authority, which at any time is legally left in the hands of the Crown. Every act which the executive government can lawfully do without the authority of an act of Parliament is done in virtue of this prerogative. So signing treaties, declaring war, promoting and demoting people, sacking from the cabinet, appointing them to all sorts of offices of profit under the Crown, benefices and so forth. The royal prerogative of mercy, pardons, and so on. All right, and then come on to Blackstone in his Commentaries on the Laws of England. This is 4-volume work, which he published from 1765 to 1767. And this is what Sir William Blackson had to say: that the special preeminence which the king hath over and above all other persons, and out of the ordinary course of common law, in right of his regal dignity. So that's what he thinks about it. So it's outside the scope of normal law. Okay, so then we're going to look at some of the various aspects of the said royal prerogative. So they are legal in nature, and only the Crown has them, because there's the king or queen's personal power. And obviously, you go back centuries, it was much broader than it is now. So there are certain honours they can grant. What else they can bestow medals on people, make you part of the Royal Victorian Order, or things like that, member of the British Empire, and Order of the British Empire, knighting people, creating peerages, and so on. Although getting peerages, that's a bit different now. There's a sort of an appointments commission to try and determine that you're a suitable person before the ministers will advise the monarch to appoint you. Okay, so it's usually these powers are exercised in her behalf by Parliament or her ministers. So the House of Commons Library, a briefing paper, explained what the royal prerogative is, and it said that there are three key principles of the same, and these are: number one, the supremacy of statute law. If it collides with prerogative, then statute will take priority. Number two, that prerogative is still restricted by certain common law principles. These are fairness and reason. So you could challenge prerogative review, prerogative by judicial review, though that seldom happens. And indeed, it famously happened in September 2019 with the prorogation of Parliament, which was overturned by the UK Supreme Court. Number three, so prerogative can be done away with by statute, but it can't be broadened. So it's limited, sort of a one-way ratchet. You can reduce it, you cannot increase it. So Parliament could create powers through a statute which are very akin to prerogative powers and what they can do. So anyway, we'll look at the prerogative powers which are still used by the monarch, or really by politicians who are elected, using them on behalf of the head of state, and what the restrictions placed on these are on how they can wield these prerogative powers. So in the last few years, there have been several public inquiries into what these prerogatives entail, and parliamentary committees have been delving into this topic. So as the House of Lords Constitution Committee, for instance, the House of Commons Public Administration Select Committee, and the Political and Constitutional Reform Committee. So in 2009, there was a rather lengthy list of prerogative powers that were named in this report named The Governance of Britain, Review of Prerogative Powers Final Report. What a mouthful. So in 2004, a report was published under the title Taming the Prerogative Power, Strengthening Ministerial Accountability to Parliament. And the House of Commons published that one. So it said that there are three types of prerogative power, and these are the sovereign's constitutional prerogatives. These we sometimes call these the personal prerogatives of the monarch. Then there are the legal prerogatives of the Crown. For example, the idea that the Crown can do no wrong, and the Crown is not limited by statute except where words say it, or the implication is just unmistakable. And lastly, executive prerogative powers. For instance, appointing ambassadors, declaring people persona non grata, or dismissing people, signing treaties, declaring war, how the Crown dependencies are governed. Those are places like Anguilla, Montserrat in the Caribbean, or the Isle of Man, Guernsey, Jersey, Sark, Alderney, the British Indian Ocean Territory, and there's a little bit of the Antarctic, something like that. So things in the armed forces, promotions, demotions, deployments. So let's go into these in detail one by one. So have a look at the constitutional or the personal prerogative powers of the monarch. Same thing, constitutional prerogative powers or personal prerogative powers. Two ways to say the same thing. These are agreeing to acts of Parliament. The royal assent, as I say, she's always agreed. for over 300 years they've always agreed. But theoretically they could refuse. Then there is appointing the Prime Minister and Cabinet Ministers, junior ministers, everybody else. Proroguing Parliament, and that was very relevant in 2019, and indeed calling Parliament. It only means when she calls them. But now that doesn't apply to all the devolved assemblies. It doesn't apply to the Northern Ireland Assembly, which I heard an ardent monarchist argue that the Northern Ireland Assembly was therefore of dubious legality. So how are these actually exercised? There are some constitutional conventions which we'll come on to later, and that makes it a bit more understandable. So these are there are legal prerogative powers, and those are limited by certain conventions. So looking at the royal agreement, or royal assent is a technical term, to law, there's a draft legislation, as in this is the proposal for it, and the monarch could refuse it, but as I say, they don't do that. So there's a convention which says that the royal assent will always be given if Parliament has passed it. And the words are said in Parliament, la reine le veut, mean the Queen wants it. So 1708 was the last time a monarch refused to do so. Appointed the Prime Minister. So this is in the gift of the monarch. But the convention is that the monarch will appoint whoever can command a majority in the House of Commons. But as recently as, say, 1963, Sir Alec Douglas-Home was appointed, despite not even being leader of the Conservative Party, and really just on the advice of the outgoing Prime Minister Harold Macmillan. There wasn't a formal election even within the Conservative Party, let alone the country. Now there could be a hung Parliament where no party's got a majority of seats, and that's happened. Well, as recently as 2017, Theresa May was leader of the Conservative Party, Prime Minister. Hers was the biggest party. They'd also had the highest share of the vote, and she was going to struggle, be a minority government, but she got that confidence and supply agreement with the Democratic Unionist Party, so she simply carried on. And by the way, it's as an election, and the default system is the Prime Minister and her governing party just carry on, unless she actually resigns. Anyway, so who's going to be Prime Minister? That's about convention, not about law. And there was this Fixed Terms Parliaments Act 2011, but also said that there's a vote of no confidence, of no government emerges, and in 2 weeks you have to have an election. What's emerges? How do we know whether it's emerged or not? Is all quite unclear. And the UK's not actually been in this situation. You go back to the autumn of 2019, there was talk of a parliamentary coup, as in that's totally lawful and peaceful, but the opposition parties plus some Remainer rebels in the Conservative Party voting no confidence in the Boris Johnson's government, bringing it down and building some sort of rainbow alliance. Anyway, they didn't even try it in the end. So proroguing someone in parliaments. So there's a Fixed Term Parliaments Act of 2011 which said that Parliament lasts for 5 years. The Prime Minister can't simply advise the monarch to dissolve Parliament and hold an early election when he or she feels like it. They used to do that, call it at a time that was propitious for them. So Parliament can be dissolved early only if the 2/3 of the House of Commons vote for it, so a supermajority. And indeed, in November 2019, Boris Johnson got what he wanted because the Conservative Party on its own wasn't big enough to get that 2/3 majority for an early election, even if every single Conservative MP voted for it. But luckily for him, most Labour MPs voted for it too, so there was the early election. Anyway, so proroguing some of Parliament, these are prerogatives of the monarchy, but they're exercised by the Prime Minister, as I said. So the Deputy Private Secretary to the Queen said so in a letter to the chair of the Political and Constitutional Reform Committee. So anyway, so next thing to look about, how do we justify these prerogative powers? You might regard them as unjustifiable. So a lot of countries have a reserve power, and that can be wielded by the executive. So Miller, in that case before the House of Lords, this is what was said by the court. There are important areas of government activity which, today as in the past, are essential to the effective operation of the state, and which are not covered, or at least not completely covered, by statute. Some of them, such as the conduct of diplomacy and war, are by their very nature, at least normally, best reserved to ministers, just as much in modern times as in the past. So those are executive matters, and they're not parliamentary matters. and therefore the legislature doesn't decide them, that ministers decide them. Remember, the cabinet ministers, roughly 25, and about 75 junior ministers. So beneath each cabinet minister will be about 3 junior ministers. So like the education secretary will have below him a sort of a primary schools minister, a secondary schools minister, and a universities minister, something like that. And the defence secretary will have below him like a minister for defence procurement, a minister for the armed forces, and a minister for I don't know what. They subdivide into different areas of responsibility. So let's see how Parliament controls these prerogative powers. Statute law and prerogative power might appear to clash. So remember that the Parliament has the legal power to get rid of prerogative powers and instead to turn these matters into statutory ones. So in the United Kingdom, remember, Acts of Parliament are the supreme form of law, and if there were to be any collision between a statute and prerogative, we know that a statute would win out. This is called the Kisa Principle, because there was a case called Attorney General and de Kisa's Royal Hotel Limited in 1921. It went to the appeal court, and it was said that Parliament hadn't plainly abolished a royal prerogative. They had simply set up a statutory scheme which was dealing with the same topic, and that the rule arose from there that in that sort of situation the Crown couldn't use the prerogative. If there's any doubt, statute shall prevail. Okay, so I hope some of these things are crystallising in your mind. So how does Parliament scrutinise prerogative powers? We know that that Parliament can hold the executive to account and can ask questions, can bring debates. There are committees which can examine these things in greater detail. Anyway, there are certain issues which are not open to parliamentary questions. You might consider that to be wrong. Anyway, so there's a cabinet manual, and it said something about military action, which you might find fascinating. In 2011, the government acknowledged that the convention developed in Parliament that before troops were committed, the House of Commons should have an opportunity to debate the matter, and so that it proposed to observe that convention except where there's an emergency and such action would not be appropriate. So that's the end of the quotation. Remember 2003, that March, Tony Blair was Prime Minister. He was proposing military action to liberate Iraq because they had very good reason to believe that Saddam Hussein possessed weapons of mass destruction, because he declared them in inventory in 1991, and also the country said, yeah, we sold them to him. But he decided he would hold a parliamentary vote on military action. He was not legally obliged to do so. It had never, ever been done before. But the majority of Parliament voted for that. So a convention has arisen since then. But when there was a military action in Syria, in 2013, I think it was, David Cameron held a vote in Parliament and it was voted down. So no airstrikes against Assad's regime. But when in 2017, the United Kingdom launched airstrikes against Syria for the use of chemical weapons, which killed hundreds of civilians, and there was no parliamentary vote on that. And now Theresa May was arguing, but this was a matter of such exigent, we had to act quickly, we'd do it. The trouble with the parliamentary vote, obviously it slows it down, and then the enemy knows you're about to do it. I mean, unless you have the troops ready to go, and they get the order go a minute after the vote. Anyway, so there was a select committee which suggested in the cabinet manual needed to be changed to put in this convention that Parliament must be allowed to debate decisions about deploying troops overseas, or them fighting really, not just being stationed there. And but there may arise some situations where there simply wasn't time, or for the sake of secrecy, this just was not practical. So the Foreign Secretary in 2013, William Hague, he said the following: "My view remains that, as I set out in my statement to the House in 2011, wherever possible, Parliament should have the opportunity to debate in advance the commitment of UK forces to military action overseas, unless there is an emergency and such action would not be appropriate. Since my statement, we have declared and formalised this understanding within the Cabinet Manual." So how does the Judiciary control prerogative powers? Well, let me get on to that. So courts have to decide what the limit of prerogative powers is, and they didn't have much opportunity to examine this. Then there was the Gchq case, that's General Communications Headquarters, as in where the UK is listening to telephone conversations, reading emails, spying, in a word. There was the Council of Civil Service Unions and Minister for the Civil Service, a 1985 case, came before the Court of Appeal. It was people who worked at Gchq were not allowed to join trades unions, and the Council of Civil Service Unions said this is undemocratic. They're being deprived of their liberties. Anyway, so the prerogative power had forbidden them from joining trades unions, and there was judicial review. Was that use of the prerogative power legal, or was the prerogative power being exceeded? Because ministers mustn't overstep the bounds of their prerogative power. But anyway, under this case, it was set out that in principle, the matters of prerogative are subject to judicial review, which have been contentious. Some argue that it wasn't. But there are certain matters of judicial review which are non-justiciable, as in which can't be brought before the court. The court just say, we can't decide, it's not within our purview, ultra vires, if you will. For example, the Minister for the Civil Service, and the Prime Minister usually also holds that title, Minister for the Civil Service, had forbidden those working at Gchq to join trades unions because it said national security would be jeopardized, and that issue was held to be non-justiciable. The court couldn't rule would it be jeopardized or not. That's not up to us. We're not making a decision on that one. So the rule is that courts will not recognize additional prerogative powers, only ones which are already extant. This comes from a classic rule in a certain case, Entick and Carrington, 1765, to which I alluded in another video, and what Lord Diplock said in BBC and Johns, a 1965 case. So this is what the celebrated Lord Diplock said: "It is 350 years in a civil war too late for the Queen's courts to broaden the prerogative." Because he is saying that Charles I tried abusing the royal prerogative during his 12 years of personal rule, shutting down Parliament and being a sort of a despot and ruling very unfairly, making himself extremely unpopular. So no, there is a restriction on what monarchs can do. Monarchs cannot get away with absolutely anything. Anyway, sometimes it's hard to tell what would be setting up a new prerogative and what would simply be applying an existing prerogative to a new situation. For instance, there was R and Home Secretary ex parte Northumbria Police Authority 1989, where an existing prerogative was supposedly applied to a novel situation. Or was it an existing prerogative? Maybe they were trying to create a new one. That was what the case was about. There was another case, R. Bancroft and Foreign Secretary number 2, 2008 case went to the House of Lords. The House of Lords said that making an order in council could also be regarded as something which was subject to judicial review. So we learned a lot about that. Well, some people want to change this word prerogative, mend it or end it, and think that this is just too broad. It's giving the Prime Minister and the Executive generally almost untrammeled powers, and that's perilous to democracy. So people have criticised it ever more stridently. Anyway, you've learned a little bit here about royal prerogative, and I think you should try and write yourself some sort of word list and then review some of the concepts which have been explored herein. So please donate to me on PayPal, georgecallahan79@gmail.com. It's all small letters. Callahan spelled Callaghan. I'm always looking for new students because I teach people law online and all sorts of other subjects. So check out my main channel, George from Ireland. Toodaloo.